Glad that you were able to join us today, and we just want to remind you of just a few key pieces as we are beginning our webinar. First of all, I should introduce myself. My name is Deborah Jennings, and I am the director here at the Center for Parent Information Resources located at SPAN, and I'm here in New Jersey with Peg Kinsell, who you'll hear from later, who is the co-director for the National RAISE Center. We ask that you introduce yourselves to each other in the chat box by typing your name, the name of your parent center or organization, your state, and also we'd like for you to include your email address, especially if you did not register through Eventbrite, so that we can forward to you follow-up resources and information, as well as ask that you complete an evaluation of this session. Okay. So Nolan, just a quick question. The box for me to advance my slides has disappeared. I think I need to be promoted to presenter.
Absolutely.
Thank you. Deborah Jennings.
Gotcha.
Thank you. Also, just a couple of reminders about webinar etiquette. You've heard this a number of times, probably on just about every webinar, but just in case. To start out, we're going to have all of the lines muted. This makes it possible for us to have a high-quality recording of the webinar without any interference in terms of background noises or conversations. We hate to have to do this, but because this webinar is going to be recorded and then archived on the ParentCenterHub.org website, we wanted to make sure that the sound is good and that there aren't any distractions. However, we do want to hear from you. We do want you to communicate with us, so please feel free to use the chat box, and there you can post your questions or comments. We will have a couple of periods where you will be able to ask questions. Peg and I will be monitoring the Q&A box, the chat box for your questions, and we'll be posing those to the presenters. You can also raise your hand, and there's a little icon just above the letter A, as in a few reminders, where you can click and you'll see that you can raise your hand if you'd like to speak during the Q&A session, and then we can unmute your line. So with that, thank you for joining us. Today's webinar is on reaching and serving students with disabilities who are involved in the juvenile justice systems. And we have a very packed agenda for this call for today. Right now I'm doing the welcome and introductions, and I will be followed by a presentation by Kate Burdick. She's joining us from the Juvenile Law Center, and she's going to talk to us about some of the really important provisions in the new Education for All Students Act. Oh man, how did I mess that up? ESSA, which is the new federal education law, and there are a number of provisions that are of particular importance for us as parent centers who are serving youth with disabilities and their families who are a disproportionate population within the juvenile justice system. Then we'll have a chance for some questions and conversation, and we're going to then talk about what are some of the strategies that parent centers are using and can use in terms of reaching and serving youth in the juvenile justice system. And then last, we'll hear from Lisa Cooper, who has put together a wonderful group of resources, a suite of resources around working with juvenile justice involved youth and their families. So now, Peg, do you want to?
So it's my pleasure to introduce Kate Burdick from the Juvenile Law Center. Kate's going to speak to you herself about her organization. We're very fortunate to have her join us today, and we hope this is the start of some really important conversations around youth that have been disenfranchised and are at risk because of juvenile justice or foster care or homelessness, which all areas of which she's an expert in. So I am not going to take any more time away from her, and please join me in welcoming Kate.
Thank you so much. I'm so very pleased to be here. And before we jump into the substance, I just wanted to say a couple of quick words about what Juvenile Law Center is, in case you're not familiar with our organization. We're a national nonprofit based in Philadelphia, but we work all over the country. And we are dedicated to making sure that students who are in the child welfare system, the juvenile justice system, or the adult criminal justice system have fair treatment and access to the opportunities that they need to become productive, successful adults. Education, of course, being a huge part of how we would fulfill that mission, and that is what I focus on at Juvenile Law Center. Our website is jlc.org, and you can also follow us on Twitter at juvlaw at 1975. We also have a couple of collaborations. We, of course, have many informal collaborations with lots of wonderful partners all over the country, including, I'm sure, some of the folks who are listening in today. But we have a formal collaboration with Southern Poverty Law Center, Education Law Center of Pennsylvania, and the American Bar Association Center on Children and the Law that we've deemed the legal center for youth justice and education, which has a mission of ensuring that all children in the juvenile and criminal justice systems can access their right to a quality education. So that's something that we got off the ground this past year. It's modeled on a similar legal center for foster care and education that we have with the same partners minus SPLC that's been in place since 2007 and has a ton of resources related to kids in foster care and making sure that their educational rights are met. So I will talk a little bit more about what the Legal Center for Youth Justice and Education has been working on, so a very exciting forthcoming resource at the end of this presentation. But for now, I want to jump right into the substance. And I will say also before we get started that we're talking a lot today about ESSA, the Every Student Succeeds Act, which is, as I'm sure you know, the big federal education law that replaced No Child Left Behind and was signed into law on December 10th of this past year. But because, you know, when we talk about reaching and serving children in the juvenile justice system, that's a huge topic, more than what we can do in 30 minutes. So with Peg, we decided, I think, to focus in on what these newer changes mean for students in the juvenile justice system. But I will, at the end of the presentation, talk a little bit more about some other relevant provisions that you are probably already familiar with, but you know, we want to make sure that you're aware of as well. So I'm really excited to be talking to you about this because, unfortunately, students with disabilities are entering the juvenile justice system at a rate 5 times higher than that of youth in the general population. So it's critically important that resource centers that are serving students with disabilities be aware of provisions under the law that can promote education access for students with disabilities in the juvenile justice system. And really, and what those unique challenges are that students in the juvenile justice system face. The other thing to keep in mind here is these are all populations that tend to be really siloed, and I think even as advocates have been looking at the Every Student Succeeds Act, that it's been kind of this like, well, here's what the foster care advocates say, and here's what the disability rights advocates say, and here's what the juvenile justice rights advocates say, when really so often we're talking about the same child who is a student with disabilities, who's dually involved, who has, you know, maybe identifies as LGBT. So we just want to make sure that we recognize the intersectionality of the populations that we're talking about here. But I'm very excited to have your attention so that we can make sure everyone's aware of the new provisions. So this really underscores what the last slide said, that there's a disproportionate need for special education services among children who are in the juvenile justice system. Some studies estimate as high as 77.5%, and that another study says nearly 4 times as many youth with have special education needs when they're involved in the juvenile justice system compared to the national average of students with disabilities. So it's, again, really important that we be looking at this population as disability rights advocates. And in general, students in the juvenile justice system are chronically behind in school and are not making progress while they are in the juvenile justice system. There are additional problems on reentry. So on reentry, again, I'm going to get more into all this. I'm just sort of setting the tone here. The sobering statistic that we have to face is that 2/3 of students drop out as they exit the juvenile justice system. Obviously, that's a huge number of students. It's a statistic that we are trying to change. But to give you an idea of why that is, I wanted to bring in the voices of some of the youth advocates that I've been fortunate to work with here in Juvenile Law Center. We have a youth engagement group we call Juveniles for Justice, who are young people who currently or formerly have been involved in the juvenile or criminal justice systems and want to advocate for change in those systems. And 2 years ago, Juveniles for Justice put together this report, Justice for Juveniles, Youth Recommendations to Improve Educational Outcomes for Youth in the Juvenile Justice System, that you can see a picture of on the screen, where they shared their policy recommendations based on their own experiences. One young woman shared that when I left a juvenile justice facility and returned home, I was only 1 credit away from graduating. Unfortunately, my public school said that they would not accept my credits and that I would have to go back to the 9th grade or take GED classes. That young woman did actually go on to take GED classes, but that is not the case among all students who realize that their credits haven't transferred, and it's a big problem that we see on reentry. Another young woman shared, after I left my placement, I tried to re-enroll in my community school, but was told that I would be denied entry because I had been truant. They thought she had been truant because nobody in the juvenile justice system informed her school that she had been adjudicated and was in a juvenile justice placement. So the school marked her as truant, and when she came back and wanted to re-engage in her education, she had to go to truancy court, which I just think is, absolutely absurd, but a real example of how these systems become siloed and there's not enough conversation among the youth serving systems. And Peg asked me today to talk about how to get started, how to reach students who are in the juvenile justice system. Where are these kids? How do we meet their needs? And so my advice would be that relationships are the key. Oftentimes these are students who are already being served by multiple providers. They are going to have a probation officer. They're going to be involved in the courts. They are often getting court-ordered on reentry to different types of community-based programs that help them stay on track with their education. Either they're court-ordered there, like I said, or they could choose to go there on their own. And of course, at the time that they are first adjudicated delinquent, they have a lawyer, oftentimes from your local public defender's office. So I think the most successful examples of having ongoing programs to serve students in the juvenile justice system, especially students with disabilities, are when you have a formal collaboration. So with one of those groups. So I would really encourage your parent centers to reach out to the public defender's office, to reach out to the local probation office that serves juveniles to figure out what are the community-based organizations that tend to be serving these young people, and put something into place to make sure that you are both aware of the services that the other one is able to offer, and that you have a chance to meet with the young people and assess their educational needs and offer your services. For example, I know of one protection and advocacy organization that has a really wonderful program where they actually are physically in the juvenile court with some frequency, so they're able to do intake interviews there, provide brief advice, and that's been a really nice way for them to actually make sure that they're serving this population, that everyone is aware of what they're able to provide. And I'm really also looking forward to hearing from you in the latter part of this presentation about what has been successful with your own organization, because I'm sure many of you are already regularly working with this population. So again, today we've chosen to focus on Title I Part D of the Every Student Succeeds Act. And I will just highlight, because I know some people are different kinds of learners. I personally like to have a handout, so this link goes to a fact sheet that's just 4 pages that walks you through what the different, kind of summarizes what the different changes to Title I Part D of the Every Student Succeeds Act are. So I encourage you to download that either now or after the presentation to track what the provisions are that I'm highlighting. I also want to make sure that you're aware of the National Technical Assistance Center for the Education of Neglected or Delinquent Children and Youth, and I should have said up front that Title I Part D of the Every Student Succeeds Act is specifically targeted to students that they call neglected, delinquent, or at risk. And NDTAC for short, this Technical Assistance Center, has an amazing website with a ton of resources on it. It talks about Title I Part D, specifically what it is, but it also has just a lot of other information pertaining to students with students in the juvenile justice system, students who are neglected or in foster care as well, and meeting their educational needs. And you can go on here and see facts for your own state also, and who the Title I Part D coordinator is for your specific state. So I think that it's really important to be aware of their website. And I will also say while we are here that Title I Part D has 2 subparts, and under the first subpart, it's a funding stream, of course, from feds to state and local agencies. And the first part, subpart 1, is where state educational agencies receive funds by formula, which they can then subgrant to other state agencies serving neglected or delinquent children or youth. Whereas subpart 2, the state educational agencies award funds to local educational agencies in the state with high numbers of children and youth who are in locally operated juvenile correctional facilities, which includes community day programs. So that's kind of the framework for Title I Part D. And there are 3 broad goals of the law. Excuse me. So the first is to improve educational services in local, tribal, or state institutions for neglected and delinquent children and youth in order to provide opportunities to meet state academic standards. The second is to improve youth transitions from institutionalization to further their schooling or employment. And then third, Title I Part D aims to prevent the dropout of youth and provide young people returning from correctional facilities or institutions for neglected and delinquent children and youth with reentry support to ensure their continued education as well as the involvement of their families and communities. So now I'm going to go into how the Every Student Succeeds Act changed Title I Part D, because I want to be really clear. Title I Part D existed before. These broad goals remain mostly the same. But I do think that there are some really key changes that strengthens language in Title I Part D that can be advocacy tools that I just want to make sure that everyone's aware of. It also kind of provides us a platform as we walk through these changes to talk about why I think they're important and why they sort of are a response to a particular barrier that young people in the juvenile justice system tend to face. So the first thing I want to highlight is that with the changes under ESSA to Title I Part D, state agencies must now establish procedures for youth to be assessed to identify their educational needs when they enter a juvenile justice facility. And so they had a portion in there before about educational assessments. What changed is now there's an emphasis on that occurring when a youth first enters a facility. And as I'm sure you can all understand, identifying students' educational needs as soon as possible is a really important thing to do, because we don't want educational issues to go on for a long time without being noticed. We don't want kids to languish without getting the services that they are entitled to and that they need to progress. So having that extra emphasis on making sure the assessment happens as soon as possible, I think just acknowledges that and is an important addition. I will note that the law says this should occur when practicable. This is not defined in the law. It's something that actually we and other advocates working on this have asked the feds to clarify when practical means, and to limit the interpretation of that, so that when practical essentially means that this never has to happen. But we have not yet received any guidance or regulations from the federal government that would clear that up. I don't know if we're going to get any. The last kind of request for comments on regulations didn't include anything about this provision. We wrote some in our response, but I'm not sure that anything is going to happen with this administration, but we shall see. So another really important thing that ESSA does is it facilitates the transfer of educational records. I'm sure, again, many of you can relate to the very difficult sort of red tape issues that come up when young people are moving between schools, and in particular between schools in different systems. So into a detention facility, out of a detention facility, into a longer-term secure facility, out of the longer-term secure facility. If their educational records are not quickly and seamlessly transferring with them, we know that a whole host of problems can occur. The new school doesn't realize, for example, that they have an IEP and that they're entitled to certain services and accommodations, specialized instruction, that they maybe an evaluation for special education services was started by the previous local educational agency, and the clock is ticking for completing that. If their records don't transfer with them, there may be no way that the new place would understand that they have the obligation to complete that. They might not have their most recent evaluation, which allows them to more effectively serve the young person. And as well as just simple things like what grade are they supposed to be in, what credits have they received, are they on track to graduate. All of that is stuff we want to go along with the youth to complete the picture of who they are and what their educational needs are. But unfortunately, that transfer is something we've heard from many advocates across the country can be a real problem. So ESSA addresses that by requiring correctional facilities to work with the youth's family and the local educational agency to make sure relevant academic records and plans regarding the continuation of educational services for the youth are shared and transfer with the youth to the facility. So I find that to be one of the best parts of the changes to the law, just because of what a huge barrier that records transfer can be. There's also an increased emphasis on reentry planning. So IRA added think exit at entry. That's not language from the law. That's a phrase that you'll hear many advocates working in this arena say, just as kind of a catchphrase to make sure that folks are aware that as soon as a young person enters a juvenile justice facility or the juvenile justice system in general, we already need to start thinking about what it's going to be like when they're exiting that facility or that system. Really acknowledging the fact that long-term planning is necessary to make a smooth transition. We can't just say, oh, the court's now ordered discharge 10 days from now, what's the plan for this kid, and think that there's going to be a successful reentry. I think exit at entry the most often, but I've actually even heard recently some people saying think exit at sentencing or think exit at the time of adjudication. Really, again, acknowledging that these students need long-term plans that they are themselves involved in to make sure that when they do reenter the community, it's a smooth transition and they're going back into a program that will further their needs. So what does that mean under ESSA? ESSA requires correctional facilities to work with the local educational agency to coordinate educational services so as to minimize disruption to a youth's education when he or she exits the facility. Again, and this is sort of true for most of the changes to Title I Part D, there's not a ton of detail on how they're supposed to carry that out, but the language itself is very powerful and can be a tool when you, as advocates, are working with young people who are forming relationships with the correctional facilities, with the local educational agencies, and working on behalf of the young people themselves. So I touched on this before. Credit transfer is a huge, or lack thereof I should say, is a huge, huge barrier for young people in the juvenile justice system. As hopefully the quotes that I shared up front from our youth advocates indicated, if folks' credits aren't transferring, it really can set young people behind. I think, to me, it seems, this is anecdotal, but it seems to be one of the biggest contributing factors to that dropout statistic that 2 out of 3 young people are dropping out of the juvenile justice system, dropping out after they return from the juvenile justice system. Because if you start to think about it, if you are in a program, they think they're earning credits, they're going to school, they're doing everything they're supposed to, and they're 18 and they believe that they're in 12th grade, and then they exit and everyone's telling them, wow, you're doing so well. They come back to their home school and their home school refuses to accept their credits and tells them they're actually 9th grade or in 10th grade. That I've heard a lot of young people say, well, this is ridiculous. I've already taken those courses. I don't want to be with 9th graders or 10th graders when I'm 18. I'm just going to drop out and get my GED, drop out entirely, maybe try to get a job, and then it doesn't always work out like they think it will. The GED, is harder than what some young people are able to do. They can't always find a job, so that can lead to some really negative outcomes. And there are many reasons why local educational agencies might not accept credits. It may be the way that the credits were tabulated while they were in the facility wasn't something that the school would recognize, or they weren't there long enough to get the credits or take the exam that would give them the credits. It may just be that the local education agency doesn't trust the quality of the credits from the facility. Maybe the teachers weren't licensed appropriately, something like that. So it's a really big issue. And what ESSA says is that state educational agencies must ensure the timely transfer of credits earned while in juvenile justice placements. So that is a very, very powerful recognition of the fact that this is a big barrier, and the language of must ensure timely transfer, I think, again, can be a very important hook to be aware of. So another problem we see is that young people are often returning from juvenile justice placements to programs that are not appropriate for them. So we see all too often that they're being pushed into alternative educational programs that rather than being put into their home school that they came from or into another program that would meet their needs. A lot of twilight programs, online cyber programs, or schools that are kind of disciplinary type schools for students who've been expelled, for example. In Pennsylvania, we have something called Alternative Education for Disruptive Youth. Students are not, under our state law, allowed to be automatically sent there after returning from juvenile justice placements, but unfortunately they still are in many times, or even if they're not automatically sent there, there may be a sort of informal hearing that there's no appeals process for that determines that they're still disruptive, and even though they've been, determined to be rehabilitated, and they're put back there. And we find that often those programs, are not providing the same quality education as their home neighborhood school or another school that would be more appropriate for them would be, and that kids fall farther behind. They find that there are difficult sort of points systems that make it really hard to get out of the alternative school, and so that also causes, in my experience working with young people, many to say, I'm just going to drop out because I'm not learning anything at this school, it's not a safe school, or whatever reason. So we want to make sure that young people, as they come out of education, out of juvenile justice placements, are re-enrolled timely into the school or program that best meets their needs. So the ESSA does require that. It has a requirement that state educational agencies establish procedures to ensure youth leaving the facilities are timely re-enrolled. And it does still offer the option of students going to alternative placements, alternative schools. The law does leave open that possibility, but we think that the language around best meets the student's needs is an important addition, and will hopefully mean that fewer students are shunted to programs that are not appropriate for them. And we want students upon reentry to still have lots of access to educational opportunities. So in addition to that provision that I just covered regarding timely and appropriate re-enrollment, the ESSA requires that state educational agencies must provide opportunities for reentering students to participate in credit-bearing coursework while in secondary school, post-secondary education, or career and technical education programming. And as appropriate, the local agencies that are seeking funding also have to forge partnerships with higher education institutions or local businesses to facilitate post-secondary and workforce success for reentering youth. So this could include opportunities for youth exiting correctional facilities to enroll in credit-bearing coursework while they're in secondary school, or they can enroll in post-secondary education or participate in that CTE type programming. And I think all of this is really important just because, A, it recognizes that education continues beyond when students are in the juvenile justice system. And B, the emphasis on CTE and coordination with businesses, workforce success acknowledges that those sort of career pathway skills are also very important for these young people. Among other things, it can help them stay engaged in their education and also provide those obviously really important skills to work towards independence. So we like that provision of the law as well. Another thing that we see happening a lot is that young people are not given the opportunity when they're in the juvenile justice system or exiting the juvenile justice system to have access to a regular high school diploma, and instead are pushed towards a GED or another high school equivalency. There seems to be kind of an assumption that if a student is overage, undercredited, that they're not going to succeed with a regular high school diploma, that there's not time for them to get a regular high school diploma, and that therefore they shouldn't even be given the option of obtaining a regular high school diploma, even though in many states students do still have the right to work towards a regular high school diploma until they're 21 or beyond. And the reason that this is important is, we don't want to limit our options for students in the juvenile justice system just in general, but also the research says that although a GED is a good thing to have, it's better than having no high school equivalency, that students who have a traditional high school diploma tend to earn more money and have better outcomes in the long run than students who have solely a GED. So again, we don't want to be making assumptions about the capabilities of students in the juvenile justice system, especially for our older students who might not have as many credits. We don't want to limit their options. So the nice thing that ESSA does that addresses that is that state agencies as well as correctional facilities have to assist youth in the juvenile justice system in attaining traditional high school diplomas. And in fact, one of the accountability standards that Title I Part D has is devoted to increasing the number of youth attaining high school diplomas in the 4-year adjusted graduation cohort rate, or the extended graduation cohort that is established by the state or their local jurisdictions. And they have to provide program evaluation data on the number of youth served who graduate on time. So these three, kind of the language, emphasis on prioritizing traditional high school diplomas, as well as the two accountability measures, we think will hopefully make it so fewer young people are just assumed to be incapable of getting their high school diploma, or that facilities only offer a GED option as opposed to having that as one of the many options that they provide to young people to meet their needs and be individualized. So, okay, keeping us moving here. I'm not going to get too far deep into these. I just wanted to touch really briefly on some of the other protections that ESSA puts into place for juvenile justice-involved youth through Title I Part D changes. There is an expanded emphasis within the purpose of Title I Part D to include family and community involvement. We all know that these students tend to do best when their families and their communities are integrally involved in making their education progress. So that's always a good thing to have in there. ESSA also expands the purpose of Title I Part D to improve educational services for youth in tribal institutions for neglected and delinquent children and youth. And related to that same point, state agencies are supposed to utilize funding on transition services for youth moving between institutions and schools operated or funded by the Bureau of Indian Education. And LEAs can also use Title I Part D funding for programs supporting, quote, at-risk Indian children and youth, including those who are in correctional facilities operated by the Secretary of the Interior or Indian tribes. There's also a new emphasis in the law where state agencies seeking funding under Title I Part D have to the extent feasible, note when a young person has come into contact with both the child welfare and the juvenile justice systems. I will say that it doesn't define what contact means, so it's unclear whether that is a student actually has to be adjudicated under both systems in order for them to have to note that, or if, one call or some past involvement 15 years ago in the child welfare system means they're supposed to be noting that now when the child is involved in the juvenile justice system. That's, again, something that I'm personally hopeful that the federal government will clarify. But it's important to note in there that, there's this increased emphasis on tracking the number of students who are in both systems. ESSA also adds an allowable use of funds under Title I Part D to provide targeted services for youth who've come into contact with both the child welfare and juvenile justice systems. And finally, the definition of at-risk youth under Title I Part D has been expanded to include to include youth who are at risk of being adjudicated dependent or delinquent, as well as youth who've had contact with the child welfare system, again, with contact not being defined. And it also added English language learners to the definition. So this definition of who was at risk before had those who were at risk of academic failure, had a drug or alcohol problem, pregnant or parenting, gang members at least a year behind or school, have rates in absenteeism or previously dropped out. So this adding, the adjudicated delinquent or dependent, contact with child welfare, and English language learners really expands that definition and allows the funds to be used to serve a greater number of students. So I just wanted to note, because I really feel sort of remiss in talking about ESSA and not noting all of these other existing robust laws and programs that serve students in the juvenile justice system, particularly students with disabilities in the juvenile justice system. So I just wanted to make sure that everyone, is on the same page, even though we're focusing right now on Every Student Succeeds Act. Of course, the IDEA, Individuals with Disabilities Education Act, continues to be an extremely powerful tool for young people in the juvenile justice system and otherwise who are eligible for special education services. Section 504 of the Rehabilitation Act, the Americans with Disabilities Education Act, the Americans with Disabilities Act, those federal laws are all still apply with equal force to young people in the juvenile justice system. The U.S. Departments of Justice and Education in December 2014 issued something they called a Correctional Education Guidance Package that talks about meeting the educational needs of young people in the juvenile justice system. And there are 2 Dear Colleague letters that are part of that package, one of which focuses on the IDEA, one of which focuses on other civil rights federal laws. And really the takeaway from that is all these provisions still apply. There's no special, a change for the IDEA that somehow once a kid goes into the system, they're suddenly no longer eligible for special education services. So just want to make sure everyone's aware of that, even though that's not the focus of today's presentation. Because of course, and this is something I'd be happy to talk offline with anyone more about, there are all kinds of additional issues that come up where we see young people's IEPs not being faithfully implemented when they're in juvenile justice facilities, problems with identifying who the educational decision maker is, when a surrogate parent might need to be appointed, evaluations and reevaluations and IEPs not being timely updated, of course, a bunch of least restrictive environment issues. So I don't want to give short shrift to that. And a really wonderful resource that is included on this slide is from NDTAC that hones in on particularly providing faith for young people with disabilities in juvenile justice secure care facilities. So I encourage you to check that out. Just some other resources. So on Juvenile Law Center's education page for incarcerated youth, we've tried to put a lot of the kind of major reports that have come out over the past few years, as well as our own publications. So that's a good starting place if you want more information on this topic. We also at Juvenile Law Center operate a free national listserv related to juvenile justice and education issues. We are always trying to get that listserv to be even more active, but it is at the very least a good way to get updates on webinars, new resources, new guidance or opportunities at the federal level. So I encourage you to sign up. And the way that you sign up is just by emailing me, kburdick@jlc.org, and I'll send you the registration link. There are different stakeholders from all over the country, and it has the power to be a really great resource if you have questions. And finally, we have been working very hard at the Legal Center for Youth Justice on Education with consultants from many different partner organizations on something we're calling the Blueprint for Change. It's modeled after a similar publication we have related to foster care and education. And it is a comprehensive document that will soon be online that has what we think are goals and benchmarks for what students in the juvenile justice system need in order to succeed in their education. And then the exciting part is we've been collecting examples of promising practices, policies, resources from around the country that go along with each of those goals. So we are hoping to get that into a searchable online index to make it really user-friendly. It's not out yet, but I would assume in the next few months it will be, and so I very much encourage you to get back in touch and to utilize that, because I think it will be a very powerful tool. And this is my contact information. Feel free to get in touch with me anytime with questions that you may have, and I will be very happy to chat with you. And again, that's my email, kburdick@jlc.org, and the Juvenile Law Center's website is jlc.org. So thank you, everybody, and I look forward to listening in on for the rest of today's webinar.
And thank you, Kate. We have several questions for you, and I'm going to read those that are in the few that are in the chat box. I think there are 3 or 4 in the chat box. The first 2 are related to facilities. One is, does ESSA distinguish at all between secure and community-based facilities? And the other is, does ESSA cover juvenile detention facilities that are short-term facilities?
So these are kind of related questions, and this is actually, it's more complicated than it seems. So there are ways that ESSA can cover community-based facilities, I will say that. There was some guidance left over from No Child Left Behind that, as I understand it, limited the ability of short-term facilities to collect funding under Title I Part D under, I forget which of the subparts it was. And so far, no federal guidance on Title I Part D has come out that changes that, even though I would potentially argue that there's no basis in the law to be limiting it to detention, to longer-term facilities. I will say that this is a question that sort of which facilities are covered comes up really, really often, and is something that in all of our comments to the feds that we have done with our partners related to implementing ESSA and Title I Part D, we have put in a question of asking them to clarify this and make it really crystal clear that, you know, which facilities are covered, but we haven't received that yet. So I know that's kind of a non-answer, and if there is a particular question about whether a certain facility could be covered, what I have heard folks in NDTAC who are really fabulous say is that they suggest that you reach out to your Title I Part D coordinator, who you can find on that NDTAC website, and ask them, and they'll do the research. They look at all the existing guidance. They look at what the actual law says, and they will give technical assistance and advice on whether something can count. So that is kind of what the strategy I would use to figure out whether your particular situation would qualify.
Okay. Thank you. The next question is around the discussion of the educational assessments, and you talked about how the assessments are on, in terms of the timing, isn't necessarily defined. Are there access points where parent centers and other advocates can actually look for ways to impact or advocate around making sure that the educational assessments are timely and appropriate? Are there any provisions that have to be addressed in state plans, or are there particular ways that we can find, say, the data of what is and isn't happening in our states?
That's a great question. I'm not sure if the data looks specifically at that, but it would be worth looking into, and I can follow up with that person afterwards if they're still curious. I will say this, just to give you a little bit more detail on what the law actually says. So this comes under the part of Title I Part D pertaining to state agency applications. So it says any state agency that desires to receive funds to carry out a program under this subpart shall submit an application to the state educational agency that, 1, describes the procedures to be used consistent with the state plan under section blah, 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 to assess the educational needs of the children to be served under this subpart, and this is the part that got added, and to the extent practicable, provide for such assessment upon entry into a correctional facility. So again, this emphasis on assessing the educational needs of the child isn't new. What's new is that it happens straight away. And so I'm not sure, again, if the data will tell you what's happening there, but I would encourage you to get in touch with the Title I Part D coordinator for your state, and they should have more information about what's happening. And those relationships that I mentioned up front, if you can have a good working relationship with the correctional facilities for young people in your jurisdiction, then this is the type of thing where you can set up a meeting with them, ask them what they're doing around this, provide what you think are good examples of educational assessments that they could be using at different stages, and really walk them through it, help them understand why it's so critically important to identify those educational needs ASAP.
Okay. The next question is in some ways related in terms of the systems piece and the state plans, and that is who is responsible for ensuring that educational instruction in juvenile institutions satisfies this one is, it says common core requirements or other core state standards requirements of public schools. What happens to graduation requirements that are related to passing state tests? I guess that's sort of two questions.
And so on the first point, I believe that it varies by state. So for example, in Pennsylvania, for the majority of our local facilities that are privately run, which is where most students involved in the juvenile justice system are, if there's such a secure placement, typically it's to a secure facility around the state that is privately run. The LEA, local educational agency, where that facility is located, is the one that is ultimately responsible for providing their education, which is a little bit confusing to some people who are like, well, but if they're getting educated on site, why is the LEA responsible? Or if their home district is the one paying for it, why is the LEA where the facility is located the one responsible? But that's how we have it set up. In contrast, there are some states that have the juvenile justice system is their own LEA. So I believe, for example, New Jersey and I think Georgia are examples of places where the Juvenile Justice Commission, or whatever it's called in Georgia, is its own LEA. So I would encourage you to look into state law where you're located to get a little clarity on that. So sorry for the non-answer, but I do think it differs. The second part, which I believe was asking, if I'm remembering correctly now, about kind of graduation cohorts and whatnot, that's a little bit more complicated. There actually is a proposed, part of the ESSA that's not in Title I Part D actually allows for students to be removed from the graduation cohort if they are transferred to a juvenile justice facility, in the same way that they would be removed from a graduation cohort if they, move to a new district long term. And there was a proposed regulation that came out from the feds that has not yet been, promulgated officially, that closes that loophole a little bit, explains that that doesn't necessarily mean just they leave for a day and they're out of the graduation cohort forever. But I'm not sure exactly how that is going to come out because the regulation hasn't been made official yet. I know we and others submitted comments on how we thought it could be strengthened. So again, there may be something that I have to answer more specifically. And I certainly do not purport to be an expert on the entirety of the Every Student Succeeds Act, which is a very complex law, and that I think a lot of people are still wrapping their heads around, even though it's been out for, 9 months or whatever it is at this point. But I would be happy to work with someone offline to kind of dig into that.
Now, we absolutely understand that exactly, and also that the differences that there will be differences or continue to be differences from state to state in terms of what many of these definitions end up being. So I appreciate that answer. There is a question or comment. One major problem in the law is that there is often a conflict between LRE under IDEA and the new ESSA Title I regs. I'm not exactly sure what that means. At DREDF, we found that reaching out directly to develop relationships with special education and principals at county schools and being sure to understand all county options is essential to help prepare a parent educational rights holder for a placement-focused IEP. I guess this is in, Cheryl, are you primarily talking about in the exit, when exiting? Cheryl is writing. How can a parent advocate if they don't know an option exists? Cheryl, maybe? Oh, yes, we're exiting. Okay. Oh, Cheryl, you have a lot going on here. You need to talk. Okay. Nolan, can you unmute Cheryl's line?
Yeah, Cheryl, what number did you dial in from?
Cheryl is dialing in from Northern California.
She just shared her number in the chat box.
All right, Cheryl, you're unmuted. Cheryl?
Can you hear me now?
Yes.
Yeah.
Okay, sorry. Those things weren't necessarily very related, so I really apologize. As I was going, I was typing, and then nobody was interjecting in between, so it looks like they're all a common thread. So the first point was just a comment, which is that as students are exiting, it's, one of the things we're learning here at DREDF is that there's very often these placement discussions that involve a special ed team and maybe probation, and sometimes we can even bring probation officers into the process, and even the courts. But what happens for parents is that it's presented to them as a sort of fait accompli. This is what is going to happen. This is the option for your child, and so on. And so I just wanted to make the point to everyone that it's very important for families, in order to participate effectively in these processes, to understand the range of options that exists at the county level for these kinds of placements, because if you don't know it exists, it's very hard to say, no, we don't accept the continuation school program credit recovery because my child was actually on track to, take UC eligible courses and, still has that plan, and so on. So that was just a point. And also just to say that just from the parent center perspective, providing materials to families that are really tailored to families whose kids are court involved in some way is really essential, because I find that there's often, when kids are entering the court system, parents are overwhelmed and stressed and anxious, and they often can't do anything but focus on the emergency. And then, when they start to realize, oh, wait, is this what's going on with the education piece, it's often a little bit after the crisis has passed. And so providing accessible materials to the people that they're interacting with at the hall, in the court schools, in the long-term placements is really essential. And I'll just leave it at that. The rest of it, let's let other people get involved.
This is Kate. I'll just say that I completely agree with the points that Cheryl raised, and we see it, unfortunately, a lot of times families are sort of counseled into or out of different options, again, because they don't understand their rights or the panoply of opportunities that their child should be entitled to. So it is important to make sure that everyone is aware of that.
Okay, thank you, Cheryl and Kate. Thank you for those comments and those questions. And actually, Kate is, Cheryl, you are helping us transition to the next section of the webinar. I think we're running a little bit over time. If people don't mind hanging around for extra time for this last portion of the discussion and conversation, I'm going to turn it over to Pat Kinsell.
So, afternoon, everyone. We're hoping just to get a little bit of feedback from the centers out there on how you're working with youth involved with juvenile justice. And then as a follow-up, if your state's using the OSEP Technical Assistance Directive that Kate had spoke or referred to earlier, the State Correctional Education Self-Assessment. So if anyone's willing to share, we're going to take the questions typed, or are we going to try to unmute lines? Let's try to talk. We're going to start with Cheryl, and anyone else that wants to join, please give your first name so that we can have it for the closed captioning. And don't forget to use the little person with the hand raising so that we can call on you. Jill, you want to talk about what DREDF's doing?
Okay, so, for a long time we had a CPRC grant to serve basically foster youth. And one of the things that, and families whose kids are involved in foster care in some way, and we trained a lot of child welfare workers and so on. And it quickly became apparent to us that the artificial, and I think that this was raised by the presenter beautifully, the dichotomy between, kids in foster care versus court-involved youth, and, dependents versus wards, and here in California it's 300 versus 600, all this lingo, that these were the same kids, and that these were often also the same kids who had county mental health services, and not always, but often, and these were often kids who may have been involved with parent centers, around disability issues and trying to get 504 plans and IEPs. And so there's all this tremendous overlap. And that, I think everyone who's on this call understands that the school-to-prison pipeline stuff, if we're really going to start to address it and disrupt it, that helping families participate more effectively around on education issues is central. So, some of the things I've already mentioned. One is to really make sure that materials are straightforward, contain very direct information, are available in formats that families can access, including different languages and so on, is appropriate. Also, I just can't emphasize enough the first couple of slides, the one around developing relationships, because I think very, very often where we can be most effective in helping a family who's dealing with these kinds of situations best, given our expertise in the parent center world, is that when they hit these roadblocks, often the existing relationships we have with special education directors, with county offices of ed, with SELPAs here in California, makes all the difference. And so, just being able to, I think of it as directing traffic, like who do I call, what are my options, who are the main point people, and developing that material for all of the PTI staff so that it isn't just one expert, but everybody knows where to find, that kind of information is central. And then finally, I think just the more we can get training on the, I think, pretty exciting emerging research on trauma-informed practice, because very often the parents that we're serving and the youth that we're serving have substantial trauma history and background. And so when we're trying to develop special education supports or 504 supports, one of the ways we can really contribute is in helping develop education programs for kids that take those needs into account so that we can try to prevent this from happening on the front end, but on the back end, start helping families develop IEPs that really take into account trauma-informed practices and get kids the kind of help that they're going to need so that they stay out of the system long term.
Thank you very much, Cheryl. Appreciate that. We're going to now, Deanne, is that your hand? Go ahead. Are you unmuted? No? I don't see it. Do you have another hand up? Okay, then I'm going to ask our next question because I guess we lost somebody on this. We have technical assistance that's working here. No? So I wanted to ask one quick question about the state correctional education self-assessment. That's the OSEP tool that was a draft tool to use for the states to use to assess their own correctional educational systems for juvenile justice and folks with disabilities. And we just wanted to know if any parent centers out there were aware of it, know if their states are using the self-assessment tool. It's not a requirement, but a best practice issued by the department. And we're hoping to get some information if they're being utilized at all out there. So if there's any information out on this call and you'd be willing to share, we'd like to know. Deanne was the name to the question on whose name did we say?
Right. Am I unmuted yet?
Oh, there you go. Okay.
Oh, good. Oh, good. This is Deanna Unruh from the University of Oregon, and I'm one of the model demonstration recipients from the Office of Special Education Programs. And I see our project officer, David Ebenheiser, is on. But the Office of Special Ed Programs has 3 demonstration projects that are really focusing in on youth with disabilities in the juvenile justice system, specifically related to reentry. And Oregon is one of them, and we have 3 sites that we're focusing specifically on making sure of a smooth, seamless reentry back into the school system and to the workforce and community for these youth. And I can say that what was presented today was very much on target for both some of the barriers that are being presented to youth upon reentry, and then also some of the strategies for ensuring that youth are successful within school, specifically around defining the appropriate school placement for youth based on the academic and social and behavioral needs of the youth. I think that's critical. We've seen across time that students are often pigeonholed into some educational settings until they, per se, fly right, and then they can be channeled into other educational opportunities. And so I think it's very important for strong advocacy to happen to assess and support youth in what their educational desires are and what would make the youth successful within that. And then secondly, that key of building relationships is so important. And so really building the relationship between the family, the school, and the probation offices are critical. And we found that educating both the school relative to juvenile justice, but also educating juvenile justice about specifically IDEA law is critical to helping build that relationship. And so if parents and advocacy groups can support that, I think that would be a wonderful movement forward.
Well, thank you so much for sharing that. We're so excited about the information and the expertise that have been on this call today. Moving forward, we look forward to taking the next steps in advocacy and education for all of us. We also wanted to have some conversation about what we can do to best support the centers in reaching these youth. And unfortunately, we're about out of time, but we did leave a blank on the evaluation forms for that information. I take a quick hand or a quick written in question or suggestion, but this is something we really want to explore, and as you can see just from the resources and expertise that we have on the call today, we're going to make a serious investment in this over the next year. So please share your ideas with us for what resources will help you guys. Deborah?
So as we're talking about resources, Lisa Cooper, do you want to talk about the resources on Parent Center Hub?
Yeah, yes, this has been a fascinating webinar. I've learned so much. It's such a big issue and so critical. We put together this handout page and it's not an exhaustive list of, certainly not an exhaustive list of resources you can turn to get more information, but it's roughly organized about identifying federal agencies that offer support and information and technical assistance with respect to youth with disabilities and juvenile justice, centers on juvenile justice, such as the one Kate works with, actually materials produced by or for parent centers, real specific to them, and then other organizations and entities. We also have added, I know we're really limited on time, so I'll be very brief, but when you go to the Parent Center Hub, to the resources page, we've added under the topics, key topics, juvenile justice. So if you can either search in the box at the top of the page, or you can click on the actual topic, juvenile justice, and a limited number of resources will come up that are different from what you see on this handout. Like Peg says, we're really interested in beefing up and continually adding information that'll help you. So if you know of resources or would recommend resources to your fellow colleagues, I would say, I'm going to put my email address in here. Email me, or email Peg, or email Deborah, or Nolan, or one of us, and we can spread the news, add it to the repository, and it becomes the part of the bigger collection that's at the hub. Deborah? You can see the link. I'll put the link at the bottom. I'll put it in the chat box to where this page is, so that, because I know sometimes it doesn't come through. The page is right there.
Great.
And we'll be soon having the archive page of this webinar up, and you can access that as well, but it's not up yet.
Excellent. Thank you, Lisa, for keeping us resource-rich.
Part of, just one second, part of the question that Letitia asks, can you send a link to the OSEP self-assessment that you discussed? One of the things that's on this resources page, the handout, is the entire package, the Dear Colleague letter, the tool, the self-assessment, all of that. They're direct links to those federal, the materials that came out of OSEP. So if you go to that page, you should be able to find the OSEP self-assessment that we've been talking about.
Great.
Okay,
Thank
Deborah,
you.
sorry.
Oh, no. Letitia, thank you for that question. And Lisa, thank you for keeping us really having a really robust resource repository that we can share. And as Peg has mentioned and as Lisa has mentioned, we will have a major focus over the next year in making sure that we have the kinds of resources that are going to be helpful for parent centers' work with families and also with systems. So we do want to make sure that you answer that question, but you will find it here in the webinar evaluation. You can click on this link right now and fill out those questions. Otherwise, you'll receive an email from Miriam in a couple of days asking you again. And we really would like to hear from you, your feedback on the webinar, but also please respond to the question about the kinds of resources and tools and materials that are going to help you in this area of parent center priorities. And with that, everybody click through to the evaluation link. You don't have to see the next slide because it just says, oh, it's the last slide. Okay. The last slide really should say thank you. And thank you so much for your time. Please don't hesitate to reach out to us and let us know if there are areas that you have interest. We have another webinar for the RAISE project that will be coming up in November because we know that your September webinars have been jam-packed. And so look for those announcements for the upcoming webinar topics. And also please feel free to share with us topics that would be of interest to you. Thanks to everyone. And thank you so much, Kate, and the SIPR team and the RAISE team. And we will see you again soon.
Thank you.